Hello and welcome to this India Today special. The judgment of the Supreme Court, a unanimous verdict in the Article 370 case, has set off a fierce legal and constitutional debate. There are those who are saying that the judgment is inimical to the federal principles of our constitution. Others are saying it's given a huge boost to national integration. How is this judgment to be viewed? Who better to answer that than the eminence grise of Indian jurisprudence and constitutional law? Fali Nariman joins me. Appreciate your joining me, Mr. Nariman. I want to start with this fierce debate over whether this judgment undermines federal principles or does it strengthen national integration. What's your view?
Well, before I come to that, Rajdeep, permit me just to say this.
Yes.
That before the judgment came, and before perhaps it was argued, because I didn't follow the argument too much, my own view was that the presidential power under 370, Clause 3, could not be exercised at all in the manner in which it was done. And for this reason, that as you know, there is an article, supervening article in the Constitution which says amendment of the Constitution. And it expressly states that each and every provision of the Constitution can be amended. Therefore, we have to judge the validity of what happened in August of 2019 by reference to that event. In Article 368, as I said, says each and every provision can be amended. It includes a temporary provision, it includes a permanent provision. And the manner in which it has to be done is that it has to go before two houses of parliament, get the requisite majority, and thereafter get the presidential assent. There is no other manner. But, and there's a big but, in 370 there is a subclause 4 which expressly states that the president is empowered also to revoke the status of a temporary inclusion in the Constitution. But it is conditioned. It says he can only do this, and you must see the proviso.
Yes.
You can only do this, that the recommendation of the Constituent Assembly of the state of J&K is necessary before the President issues such a notification. Now, admittedly, there could not be such a notification for the simple reason that there was no Constituent Assembly in existence.
Yes.
And secondly, that the Constitution of J&K itself had been abrogated. So this was otiose. But you cannot say that a proviso is otiose, for God's sake.
Otiose meaning is infructuous,
ineffective.
Yeah, because you see, the Supreme Court judgment does go on to say that the presidential order renaming the Jammu and Kashmir Constituent Assembly as the Legislative Assembly to get around 374 is not correct. But then goes on to say that the decision itself to abrogate,
that's a little jump.
So they've done a legal sleight of hand.
That's a little jump. Yes, quite right. It's a legal sleight of hand, which you are quite right. I disagree with that. That's apart from that. But therefore, what is the consequence? I mean,
yes.
Suppose I am right. Can Article 370 not be removed? It can. But it has to be done in the procedure mentioned in 368. That's my point.
So you're very clear that Article 370 is a temporary provision.
Yes, yes.
So this belief that it was, there's a permanence to it, you disagree
Yes,
with
that's
that.
what it says so.
But if you have to remove it, there is a process to be followed.
That's right.
In your view, there is a question mark over whether the process that was followed by renaming the Constituent Assembly as Legislative Assembly is the right process.
That's right.
So in your view, what would have been the right process?
Only go under 368, that is to say, amendment, which they haven't done. There's no amendment of the Constitution to get rid of 368. They've gone by presidential power. And presidential power only under 370. Once again, 370 clause 3.
And a constitutional amendment would have necessarily required a two-thirds majority
Yes, but that's
in both houses.
That's the politics of it.
Yes.
Whether they would have got the two-thirds, they would not have got it, is, to my mind, not of any significance at all. I mean, we are dealing with a constitutional question, so please let us decide it in accordance with the provisions of the Constitution.
Okay.
Whether it was urged, not urged, half urged, not urged, it makes no difference.
You make an important point, because that's the constitutional process that should have been adopted,
yes,
which has in a way been short-circuited.
Mandated.
Which is mandated, which has been short-circuited. There's an interesting editorial in the Hindu newspaper which refers to the judgment and says, the most potent attack on federal principles is the court's unconscionable conclusion that Parliament, while a state is under President's rule, can do any act, legislative or otherwise, on behalf of state legislature.
Yes, that's correct. They are also right. I'm not saying they are not right.
No, is that a concern? Because let me give you...
Yes, that is a concern. That is a concern. That is a concern. If you call India federal, of course we are not federal, we are quasi-federal.
Yes.
And that's the constitutional position also. We are quasi-federal. But all this can be done. Whatever is required to be done has to be done in accordance with the Constitution. It can't be done apart from the Constitution. That is to say, it has to be done by an amendment. Now, that amendment, whether it was possible, not possible, let us assume that it was possible, they haven't done it. If it wasn't possible, well, that's worse for them. But that's not the point. I'm not raising any technical issue. Mm-hmm. It's a constitutional issue. And the constitutional bench of the Constitution of the court had to determine this on its own. It had to determine it. Having overlooked this, it was not proper at all. But whether the point was taken or not taken.
It's a unanimous verdict.
Yeah.
And the court was being asked to look at both the effective abrogation of Article 370 as well as the downsizing of a state into union territories.
Now that's another point.
Yes.
The downsizing of the state, once again, is very, very doubtful for two reasons. One is the bench relied upon a 5-judge bench judgment of 1960, years and years ago, which I consider to be incorrect. Namely, that you have to take the consent of the state legislature. Namely, that you have to at least approach the state legislature. And having approached it, the court in 1960 said, having approached it, that's enough. You don't have to take its consent. Right. But I think that again is a very serious violation of a federal principle. Because what's the use of saying that we are a federal state and which doesn't require the consent to its downsizing from being a state to a union territory?